Okay, we're on the record in cause number DF240195. Councils, will you please announce for the record?
Brent Devnam, State Bar number 241-00481 on behalf of the petitioner, Jonathan Streeter. I've also, next to me, got Jackie Avila, State Bar number 241-48079, also on behalf of the petitioner, Jonathan Streeter. We're present and ready, Your Honor.
Thank you.
Shiva George, attorney for respondent, Your Honor, State Bar number 241-28830. Present and ready to proceed.
Thank you. With those who intend to testify, would you please take yourselves off of mute and raise your right hands? All right. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Yes.
Thank you. You all may lower your does anyone wish to invoke the rule at this time?
Yes, Your Honor, I would like to invoke the rule.
Okay, so the Streeters will remain. Let's see, who am I looking for? Is it Sterling?
Joan Streeter's mom.
Okay. And go ahead.
And let me go to our witness list real quick. Oh, right here. Then Emily Ash, is she still in here?
Yeah, I went through a name change. It's legally Cass Sterling now.
Okay, I apologize. Cass Sterling is also a witness, a bars judge.
Okay. All right. So Joan Streeter and Cass Sterling, I'm going to place you all in the waiting room until the attorneys will need to call you in as a witness. Then I'll pull you in, assuming they even get to you, okay?
Yes,
Understood.
ma'am.
Okay. Waiting room. All right. And prior to going on the record, we discussed the stipulation of some pre-admitted exhibits. Petitioners exhibits 1 through 3 are admitted, and respondents exhibits 1 through 23 are admitted as well. According to the pretrial order that you all, when you all came to court back in February, there is one issue that is before the court, a very narrow issue, a potential waste claim. Is that correct?
Yes, Your Honor, and distributing the remaining marital property, essentially.
Okay.
Judge, I agree. That's correct. I don't think there is any remaining marital property, but so yeah, the waste claim is the only thing that I think is before the court.
Okay. So I have you all, according to your pretrial order, is 30 minutes total. You all are set at 15 minutes aside. That will include any open and closing statements, should you all choose to make one, as well as any examination that you all will do. Attorney Devnam, at this time, would you like to make an opening statement?
Yes, Judge, please.
Okay, go ahead.
Judge, to be frank with you, I don't know why we're here today. This case is a waste of the court's time. It's certainly a waste of the taxpayer dollar, and it's a waste of the party's money when it comes to attorney's fees. To be frank, today there will only be 2 winners. One is my office, and the second is Miss George's, who will be paid and are being paid our attorney's fees. The fact of the matter is there is nothing remaining in this community state, nor has there been for a great deal of time. In my 8 years of practicing family law, I'm not sure if I've ever seen such a shocking legal strategy advanced by opposing counsel that just emphatically wastes the funds of these parties. There's nothing left in these the community property in this case was a house. They sold the house and distributed the funds to each other. And that's all that's left. So I'm not sure why we're here today. There are some unique facts in this relationship that I think it's important the court understands as it listens to what's in front of the court today. primarily the unique fact is this couple chose to be a polyamorous couple. They engaged in polyamorous relationships that were consensual. They're clear in the messages that have already been admitted to the court. They discussed them in great length and great volume. They were very informed. They talked about them greatly throughout the entirety of the preparation of this case. Opposing counsel has continued to refer to it as paramour, as an illicit affair, and it's plain in the text messages, Judge, that this was fully known, fully talked about. When it comes to waste, you're going to see that the witness, who was one of the members involved in the polyamorous relationship, received funds that were reimbursements from our client. They will talk about how this is fraud and how these funds were a waste of the marital estate and how this was some illicit affair. But Judge, what I think is important for you to point out, for you to see, is that this fraud is something that's done without knowledge, that's hidden, that's done in secret. This party lived with them. She lived in the marital home with both parties, and as the messages showed, they both asked her to buy things and do things and pay for things, and that's a normal course of conduct. That is not fraud. I think it's also important to notice that you will see no expert witnesses proving fraud. You will see no evidence of fraud, and I think it's also important to know that opposing party has objected to the third party credit card records of the very person they're saying the money went to waste. So you would think that they would need to prove up their waste claim to see where those funds went and what they were used for, but they've objected for the court seeing that evidence. We ask at the end of the day that the court call this case what it is. There's a separate property card that we ask the court be ordered back to Mr. Streeter. We ask that both parties be assigned their attorney's fees, which are already outrageous considering that neither party has money. And I don't know how their party's paying, but our party is paying with loans. And call this case a day. They were married in 2016, separated in 2023. The house was sold in 2023. There is nothing left to fight about.
Thank you, counsel. Attorney George, would you like to make an opening statement?
Yes, Your Honor, briefly, if I may.
Go ahead.
Your Honor, this is not simply a matter of fighting over the relationship status of the parties, and to write this off as an emotional response from my client to petitioner's relationship with Ms. Cass Sterling would ignore the financial inequities that we're dealing with here. This entire case has been a bullying technique against my client from the start. Petitioner moved out of their home on their wedding anniversary. He closed out joint accounts and took her off of insurance as soon as she was able to retain an attorney in this case. He kept the remaining joint funds and closed out accounts. He's kept the remaining proceeds from the sale of their marital home and has transferred a total of over $90,000 to his girlfriend since 2022. The entire case has been an attempt to silence, control, and bully my client into backing down, which she has simply had enough of. That is the true focus of why we're here today, and to write this off as just simply leaving with no property or not separating what has actually been done in terms of the finances from 2022 to date would be ignoring the wrongdoings of opposing party and leaving my client without a proper share of the marital estate.
Thank you, counsel. All right, Attorney Debnam, you may call your first witness.
Petitioner calls petitioner Jonathan Streeter.
Okay.
Mr. Streeter, I'm going to go quickly because we've got limited time. When did you and Miss Streeter marry?
On October the 13th, 2017, I believe.
And when did you separate?
October of 2023.
And during the marriage, what community assets did you acquire?
We acquired a house, we acquired some art, and we acquired debt.
And you mentioned the house. Was that sold during the marriage or after separation?
That was um, that was sold after separation.
And how much equity was there in the home at the time of the sale?
Uh, I don't know that answer. We ended up with 40 or 60,000 after the sale of the home.
And what did you all do with those funds?
Well, we had amassed quite a bit of credit card debt at that time. Um, and so the first thing we did was we paid off the credit cards so that we would zero out the accounts. And then, as you can see in the bank records, I then took the half of the remaining amount and immediately sent it to her account, where it then moved to other accounts that I had no visibility in.
Okay, so just to be clear, what you did with the equity, to summarize for the court, is you paid off the party's credit card debt and then split the remaining in half, correct?
Correct, down to the penny.
Down to the bank. Okay, other than the house, you mentioned there were some art assets.
None that I care about.
Got you. So what happened to those?
Those went to, as much as we could, most of it went to Ash Streeter.
Okay, and did you have any separate property assets during the marriage?
We did. So the Ford Fit, or I mean the Fit, was acquired by myself before the marriage. There was also other like art pieces and various little tools and things that were before the marriage.
Okay. And what vehicle? So that vehicle was acquired before the marriage, and what about the other vehicle?
The Ford Focus was a gift from my mother to me
Okay.
upon the sale of the previous vehicle that she had during the Dieselgate scandal, and so it was paid in cash.
Okay. And who has that vehicle now?
I have currently the Ford Focus.
Okay. And what about the other vehicle?
I assume that she has it. I have not seen it
Okay.
in a very long time.
And you're asking the court to return your separate property vehicle that you haven't seen in a long time, correct?
Correct.
Okay. Let's talk about your relationship structure. During your marriage, were you and Miss Streeter in a monogamous relationship?
No, we were in a polyamorous relationship.
And was the non-monogamous structure openly discussed and agreed to by all parties?
Yes, multiple partners, even before Cass Sterling.
Okay. And was I'm sorry, I've got to adjust here. I've got Cass Sterling's previous name. Was Cass Sterling one of the people involved in the polyamorous relationships?
Yes, sir.
And Miss Streeter is now alleging that you defrauded the marital estates by making transfers to Cass Sterling. Is that correct?
That is what she is alleging.
Okay. Why did you transfer funds to Cass Sterling?
Well, part of the funds was she was actually cleaning the house, and we had an agreement on how much pay that was. We've also asked her on multiple occasions to go get groceries for us to be able to be done. And she did various things around the house that we also paid for.
And did you ask Ash to keep your finances? Did Miss Streeter and Cass Sterling keep your finances separate from one another?
Yes, Cass Sterling had her own credit cards and banks and stuff that I was not privy to.
Okay. And did you keep a separate bank account and Miss Streeter keep her own bank account?
My understanding at that time was that she had visibility onto my account. And she was, I got and then she had her own credit card that I had no visibility into. We had a shared Sparkle LLC account. And then Ash had multiple other accounts that I had no visibility into.
So did Cash Sterling sometimes pay expenses on your behalf, like rent, mortgage, or other purchases?
Yes.
Okay. And why did Cash Sterling do that?
she was asked to either by me or Ash during the time that we were actually together.
And
then
in
after-
those messages, there's lots of discussions about you all asking Cass Sterling to buy things, correct?
Yes,
Okay. And Miss Streeter was completely aware of all of these arrangements, wasn't she?
very aware.
Okay. Did the three of you discuss these expenditures in the messages that have already been admitted to the court?
Yes,
Did you attempt to admit Cass Sterling's credit card statements to show the charges that she fronted?
yes,
And it's your understanding that opposing counsel and opposing party objected to the admission of those statements, correct?
yes.
Okay. During the relationship, where did Cass Sterling live?
She actually moved in pretty quickly into one of the bedrooms in the house.
Okay. And so you're asking the court to keep each party whatever's in their possession as reflected in our proposed relief, correct?
Correct.
Do you personally own any assets today other than the cars you mentioned?
Nominal things like pots, pans, stuff like that, clothing, like various other little items, but nothing that's
How much
anywhere
debt do you
close to
currently have?
20, 30, 32,000
And a
with
lot of that is legal fees?
most of that is legal fee. 10,000 of it is the IRS, due to having to wait for trying to get our tax situation situated in the request and waiting for the opposing party to respond to it and then having to file.
So opposing counsel's position that you've taken a $90,000 windfall is nonsense.
Correct.
Okay, we passed the witness, Judge.
Thank you. 1 second. Mr. Streeter, what was the amount of debt that you said you currently owe?
I believe it's somewhere around 32,000, but my numbers may be off for this. I have personal loans from my mom, from my brother, and other loans that I've taken out from other places to be able to pay for both the taxes and the ever increasing attorney fees.
All right. What is the tax bill as of today that you remember?
10,000 something dollar. I'm afraid I don't know down to the penny, but it's $10,000.
Okay. Thank you. All right, Attorney George Cross.
Yes, Your Honor, thank you. Mr. Streeter, have you provided any documentation of these loans that you have allegedly taken out?
Yes,
Documentations for a loan from your mother in discovery?
I supplied quite a bit of evidence and a lot of documentation at that point. The most recent one, though, was taken out due to
Objection,
the discovery.
non-responsive. It's a yes or no question. Have you provided these documents in discovery?
That's
Yes,
not what the question was. It was just asked if it was provided, not in discovery, Judge.
And
Okay.
I clarified.
Let me read it back. The question was, Mr. Streeter, have you provided any documentation of these loans that you have allegedly taken out? Response, yes. Question, documentations for a loan from your mother in discovery. Response, I supplied quite a bit of evidence and allowed documentation at that point. Then the objection was made to non-responsive. The court sustained that objection. Question, have you provided these documents in discovery? Response, yes. So, counsel, you can ask your next question.
Okay, thank you, Your Honor. In terms of the additional personal loans that you've taken out, have you provided any documentation to us through discovery on those? For these attorney's fees?
for the attorney's fees, that would be the lawyers. I did not personally.
Okay. You indicated to my client that you would become vindictive if lawyers got involved in this suit. Isn't that correct?
Incorrect.
Okay. Exhibit 6 that has been previously admitted to the court states a Discord or a text message between the two of you on November 10th. And in this message, you state, if and when I have to get lawyers, I will ask them to be vindictive about it. I was nice for too long. I am either going to finish this in a week or strive to recover all lost funds in full. Isn't that correct?
Correct.
And in your response to requests for admissions, you had denied that you had made this threat. Isn't that correct?
Correct.
When my client hired an attorney, did you close out the joint Chase account between you and Ashley?
I was following directions of my attorneys on what to do with the finances. I do not know the timing of when the attorneys were hired.
And where did these remaining funds go?
There was approximately $2,000 from a recent paycheck that I had acquired. And so I moved that immediately to another bank account for the same one. And then the $41 also was moved to my remaining account because the bank required all of the accounts to be zeroed out before they could be closed.
And you removed her from insurance when she retained an attorney as well, correct?
I followed the instructions from my lawyer at the
Objection,
time.
non-responsive.
Sustained. Sir, the question was, and you removed her from insurance when she retained an attorney as well. Is that correct?
I did not know that she had attained an attorney or not by the time that I had removed her from the insurance.
Okay, and so our office provided you with a letter regarding the standing orders in this county, correct?
Correct.
And after this letter, did you transfer the funds back, being aware of the standing orders in place?
I asked my lawyer what to do and then followed the advice that I was given.
Objection, non-responsive.
Sustained.
After the letter, did you transfer the funds back to any account
No,
that she had access to?
no.
Okay. Let's discuss the house proceeds. What was the original agreement between you and Miss Streeter regarding how these proceeds were going to be split?
We were going to pay off all of the credit cards and then we were going to split the proceeds down the middle 50-50.
Isn't it correct that the credit card debt would be paid as well as Miss Streeter's student loans?
I made the offer to pay the student loans off, and then she turned down the initial time to be able to pay them off.
Objection, non-responsive. Isn't it correct that the original agreement was for the student loans to also be paid from house proceeds?
Yes, that was the original agreement.
Okay. And you had outstanding loans on your cars, correct?
No,
The Honda Fit did not have any outstanding loans?
no.
Okay. In your request for admissions, you admitted to transferring over $50,000 to Emily Ash. Is that correct?
Yes.
And in your Chase statements provided to the court as Exhibit 14 and provided in discovery, there is an additional $45,000 in transfers over the past year. Is that correct?
Yes.
Okay. And so is it your testimony today that those transfers were to pay Miss Ash to clean your house or various other things around the house?
At the very beginning, yes, that's what that was.
Isn't it true that the transfers to Miss Ash, when that my client was aware of, were really to address groceries since she was your roommate?
Part of the funds went to groceries.
Okay. What is your income per year?
Currently, right now, or
Yes.
before? Right now is $200,000.
Okay. And yet you are claiming to have no savings account, no retirement accounts. Is that correct?
Correct.
Where are your funds being transferred to?
We had quite a bit of debt from moving. We had car troubles. We had quite a bit of expensive dental procedures to handle issues with that. We had computer troubles that I've had to have repair for, car troubles that I had to pay for.
And well, the reality is it's not sitting in your account because it's transferred out to your girlfriend. Isn't that correct?
Part of the funds are, but there's also rent and other
Objection,
groceries.
objection, non-responsive.
Sustain.
So the funds are not sitting in any of your accounts because they've been transferred out to your girlfriend. Is that correct?
I don't know how to answer this question. It's a
It's
broad.
a yes or no
Judge,
question.
I don't understand how to answer this question. She asked if all the funds are transferred out. He said part of the funds are. That answers the question. Otherwise he's going to have to lie to answer the question.
Okay, so let me read the question back. So the funds are not sitting in any of your accounts because they have been transferred out to your girlfriend. Counsel, would you rephrase that question?
Yes, Your Honor. Is a majority of your income transferred out to your girlfriend each month?
Yes, or to pay off the credit card that we have that is in her name.
Okay, and it is still your testimony that that is for groceries and for her cleaning the house?
That agreement was at the very beginning, when we were in the relationship together. Right now, she has the credit card debt that we have accrued and had to transfer over to get 0% interest on, that we're still paying off from the original move and then the debt that we acquired during that time. In various things around the house, going out to eat, using it as we would in life. Like we're paying off a major credit card from that.
Okay.
As you can
House
see
witness.
from the, what was that?
Your Honor, I passed the witness.
Okay, thank you. Counsel, let me ask something. Was a part of your client's request to relief reimbursement for the student loans?
I'm sorry, Your Honor, are you asking Mr. Debnam or myself?
Your client, you mentioned, you asked Mr. Streeter about their agreement and you mentioned student loans.
Yes, Your Honor, my client has accrued student loans during the marriage, and the agreements of the parties were that the house proceeds would go towards that.
Right. So I guess the court is I'm asking you, or are you requesting today that one of the reimbursement claims be for those student loans?
We are asking for payments to be towards those student loans as part of the requested relief, not necessarily a reimbursement claim.
And Judge,
That's why the court was confused, because by law, that's something I can't even
right,
consider.
thank you. And we've been having this conversation for months, Judge, and I'm not sure what the disconnect is. I think this is legally a very clear issue, yet we can't move two feet on it. And opposing counsel throughout the entirety of this case continues to misphrase a settlement offer and settlement conversations as some sort of quasi contractual obligation of my client to now magically owe her separate property claim. And it's just, it's
Your
crazy.
Honor, I think the side commentary aside, on the communications between counsel, because we have attempted to reach out and settle out this case and mediate this case.
Well,
Even
that's great. That part I'm not interested in. I was just
Yes.
trying to get clarification, because what your client would be asking me to do through you, by law, I'm not able to do that. I cannot entertain reimbursement for your client's student loans. That's not a reimbursable claim.
Yes, Your Honor. And so that is why we had provided a property division spreadsheet, which essentially lists out how a possible 50-50 split would look like in consideration of the debts that have been taken on by the parties. the amounts in their accounts. And because while it is listed as a possible remedy in our summary of requested relief, we had listed several other possibilities for getting this marital estate to a 50-50 split.
And I understand that, counsel. Let me say it more clear. I cannot give your client any sort of relief on a 50-50 split for a student loan. That is her separate debt.
Yes, Your Honor.
So does
50-50
your client understand that? Because if she doesn't understand it, then maybe she understands it now. I just don't want your client to believe through you that I'm able to give her something that by law I cannot give her.
Your Honor, it's been discussed. It's more so the reimbursement claims and waste claims that are listed in our spreadsheet address the transfers to the girlfriend. Now we've talked about student loans and what have you, but this expands past student loans. It goes into where these house proceeds went and why there is nothing left in the community estate.
Okay. All right. Attorney Debnam, is there any redirect of your client?
Just very briefly, Judge.
Go ahead.
Mr. Streeter, you were asked a whole lot of questions about where those funds are going that you're transferring to your girlfriend. I want to provide just two clarificatory positions for the court. One is that is it fair to say that Cass Sterling manages the vast majority of your finances?
Yes.
Makes payments on your behalf for things like mortgages or rents. I know you don't have a mortgage anymore, but rent, those sorts of things,
Yes.
right? And is that why you tried to introduce and offer Cass Sterling's financial records so that we could show the court where those finances were, so we could answer the very questions that Miss George was asking you?
Yes.
But Miss George objected to that, didn't she?
Yes.
Thank you. We'll
Your
pass
Honor,
the witness, Judge.
okay. Nothing further, Your Honor.
All right. Attorney Debnam, you may call your next witness.
We will call Mom, Miss Jonah Streeter.
Okay, and time check. Attorney Debnam, you have 3 minutes and 10 seconds. Attorney George, you have 5 minutes and 26 seconds.
Miss Streeter, did you purchase a car for your son?
Absolutely.
And what vehicle was that?
It was a Ford Focus and it was in 2018.
Did you intend that car to be a gift to Miss Streeter or just your son?
Just my son.
Okay, thank you. Pass the witness, Judge.
Okay, Attorney George.
Nothing for this witness, Your Honor.
All right. May this witness be excused, Attorney Debnam?
Yes, Judge.
All right. Ms. Streeter, thank you so much for your testimony here today. You're excused and you may log off.
Thank you so much, Judge. We appreciate you.
You're welcome. Have a good day.
You too. Thank you.
All right. Attorney Debnam, you may call your next witness.
We'll call Cass Sterling.
All right.
Cass, I have got to be real quick here, so I'm going to ask you some short, direct questions, okay?
Mhm.
Did you live with Mr. and Mrs. Streeter during their marriage?
Yes.
What was the nature of your relationship with Mr. Streeter?
I was romantically involved.
Was Mrs. Streeter aware of that relationship?
Absolutely.
Did she demonstrate that relationship, that awareness with communications to you all over the place, including Discord group messages?
Discord group messages, and I met her on my first date.
Okay. And did Miss Streeter know that you purchased items on both her and Mr. Streeter's behalf?
Yes, I got both of their approval for anything I purchased.
Okay, so she knew that you take care of a lot of the finances and were reimbursed by Mr. Streeter.
Yes.
Okay. And you expected to be repaid for expenses you've fronted, right?
Yes.
And you were willing to offer in your credit card statements to evidence for this court to see, right?
Yes.
And it's your understanding that opposing parties objected to that?
Yes.
Okay. And final question is that you you manage most of the finances for Mr. Streeter to this day, right?
Yes.
Okay, thank you. Pass the witness.
All right, Attorney George,
Briefly, Your Honor, if I may.
go ahead.
Ms. Sterling, what approved expenses were agreed upon between you, Ms. Streeter, and Mr. Streeter?
Mostly it was groceries. I did buy a $2,500 couch, which I informed them of. But I did the grocery runs so that they didn't have to get the DoorDash and have to pay for a dasher.
And if I asked you whether this amount equated to 95,000 over the course of the last 3 years, would that sound correct to you?
Yeah,
Okay, and
because
so
I mean, 95,000 was
would
during the marriage.
okay. And so is it your testimony today that my client only consented to the transfer and approval of expenses for groceries?
Groceries and for paying me for my cleaning services and for the couch.
And would that equate to the full 95,000?
It would equate for the full amount during their marriage before the separation.
And you understand they're still married, correct?
Yes, they are separated but married.
Okay, no further questions.
All right, Attorney Debnam, anything further from this witness?
No further. Can they be excused, please?
Yes. Thank you for your testimony today, and you are dismissed and free to log off.
Thank you.
You're welcome. Have a good day.
Mhm.
Thank you. Attorney Debnam, you may call your next witness.
Judge, petitioner has no further witnesses.
Okay, does petitioner rest?
The petitioner rests.
Okay. Attorney George, you may call your first witness.
Ashley Streeter, respondent, Your Honor, if I may.
Okay. Go ahead.
Ms. Streeter, what was the profit from the sale of the house?
The profit from the sale of the house was, I'm so sorry, let me pull that up. It was,
If I said that was $43,077, does that sound correct to you?
yes, I apologize.
And what was the agreement between the parties for the proceeds to be split?
The agreement was to pay off both of our credit cards, and then to split the remaining, or I'm sorry, pay off both of our credit cards, pay off the student loans, and then anything that was left over afterwards, split between the two of us evenly.
Okay, and you two continued to share a bank account and credit card after the house was sold, correct?
Yes, we did. Multiple bank accounts.
And both parties' paychecks were going to those payment of bills between the two of you?
When we were split, yes.
And the agreements between the parties were that you would keep the Honda Fit, correct?
Yes.
And have you kept the Honda Fit?
Yes.
Have you made payments towards the Honda Fit in terms of maintenance?
Yes.
And is it your understanding that there was an outstanding loan on the Honda Fit during the marriage?
Yes.
And how much was being paid towards this outstanding loan?
$300 from the start of the date of the marriage.
So
A month. Sorry,
$300
$300 a month from the start of the marriage.
Okay. Now, after Mr. Streeter had closed out the joint accounts, as he had testified to earlier today, did you have difficulty paying your bills after this was done?
Yes.
And were you working during the marriage?
Yes. Off and on. I was a full-time student, and then when I wasn't a full-time student, I did have various jobs and volunteer work that I did.
Okay, and Exhibit 3, which is a financial information statement, which has been admitted to the court, goes through your income and expenses. Is that correct?
Yes.
And how much do you currently owe in total in debt?
My student loans are a little over $16,000. And then my credit card at the moment, I believe, is a little over $3,000. It might be 4. It's somewhere between 3.7 and 4.2.
And is it your position that there would be more funds or assets in the community estate had Mr. Streeter not transferred money out to Emily Ash?
Yes.
Is it your position today that Mr. Streeter would have been able to meet the terms of your agreements had these funds not been paid out to Emily Ash?
Yes.
And does Exhibit 1, as proposed to the court, outline your summary of requested relief
Yes.
in this suit? Have you also prepared a property division spreadsheet for the court?
Yes.
And this spreadsheet addresses the reimbursement claims that you're requesting, correct?
Yes.
And with the reimbursement claims listed for payments to Mr. Streeter's property, separate property car, and for transfers to Emily, are you requesting a cash payment to bring the split to a 50-50 split?
Yes, it would total $22,009.
And are you requesting attorney's fees in this matter?
Yes.
How much in total have you paid for attorney's fees?
Just over $27,000.
And that includes fees to prepare offers, prepare for trial, prepare discovery. Is that correct?
Yes.
Attorney George, that was your last question. You just ran out of time.
Yes, Your Honor.
All right.
I have no cross, Judge.
Okay, go ahead.
I don't have a cross, Judge. Whatever time I have left, I'd like to close with it.
Okay. I have a couple of questions for you, Mrs. Streeter.
Yes.
The Honda Fit, whose car is that? Well, let me ask a better question. Did you pay for it before the marriage?
No, we purchased it 3 months before the marriage.
Okay,
So
when you
it was
say,
in his name. Mhm.
okay, so the title here is solely in his name.
Yes.
Okay, and you're saying he gave it to you when?
We purchased it for me. He already had a car. We bought it for me. And it's always been my car. And we have mountains of evidence of him agreeing that it's my car. He's never been in possession of it. It's been
Okay,
mine
but
the entire time.
you understand he bought it before you all got married,
Yes.
right? Okay,
Yes, but he did make all of the payments with our community funds.
okay. If you are wanting the court to award you the car, are you also going to take over the payments?
There are no more payments. It's been paid off since the January of 22, I believe.
Okay, maybe I'm looking at this spreadsheet wrong. Attorney Debnam, it looks like there's a balance on here.
I'm also confused. I don't think there's a balance on there, but I heard testimony that she had been paying it, and now she's saying that it's been paid off during the marriage. So I don't know when she was paying it, but I'm also confused, Judge. To my understanding, there's not a balance on it, and it's certainly separate property.
If I may, Your Honor, if you're referring to our spreadsheet, this lists the reimbursement for the payments from the date of marriage to 2022 when the car was paid off.
Okay. Okay. I guess the court is confused because there's a reimbursement claim on a vehicle that was not community property. It's the separate property of Mr. Streeter, but he's not the one asking for the reimbursement. So how can your client claim reimbursement on separate property that is the separate property of Mr. Streeter?
So we are requesting reimbursement to the community estate for the payments towards that separate property car. The payments that began from the date of marriage to when the car was paid off.
But in what you just said just proved the confusion, right? You're asking the court to give a reimbursement to a separate property claim for the use of community funds, right? But it's to a separate property, it's to separate property that belongs to Mr. Streeter. He's not the one asking for the claim. I guess the court is trying to figure out, how does your client get the reimbursement claim for community funds used on separate property? Because if I were to grant a reimbursement claim back to the community, I mean, I'm doing a reimbursement claim to the community for community funds used on separate property that belongs to the person not bringing the reimbursement claim. I guess I'm trying to figure out logistically, how do I get there?
Your Honor, so opposing party is requesting for the car to go back to him. And so as part of the payments that the community estate has been paying towards this car and to benefit this car, this separate property of Mr. Streeter, we're asking for that reimbursement back to the community for the sake of bringing the community back to a place where he is not the only one benefiting from these payments.
Okay. And Mr.
And I
Streeter,
apologize if I'm not articulating it to clarify, if I can answer any further questions.
no, you're fine. You're fine. Thank you, counsel.
Yes, ma'am.
And Mr. Streeter, you said the $22,009 is your request for what the 50-50 split would be?
Yes, based on that spreadsheet.
Okay. And just so I'm clear, the amount of debt for you is $16,000 for your student loans and roughly about $4,000 for your credit card payments or credit
Yes.
card.
Yes, Your Honor.
All right.
Yeah. Yes.
Okay. Attorney Devlin? You have 1 minute and 44 seconds left.
All right, Judge. I'm going to make it brief. I hope the court can see that my position that I started, it remains the position at the end. There was no reason for this case to be in front of this court. There is no community estate remaining. My client has $32,000 in debt, and their client has about $20,000 in debt. They come to the court asking for reimbursements for student loans that the community had probably made payments on, but now they want to be reimbursed on that. They want to be reimbursed on the car. And significantly, the main thing they brought in front of the court is fraud. And they objected to all of the evidence be coming in for fraud. They objected to the very evidence necessary to prove their own claim. And they didn't provide any expert testimony. You can't bring the claim before the court and then play hide the ball. I told you the only winners in this case would be our two offices, and they told you $27,000 in attorney's fees for zero community estate remaining. So my question, it's up to them to show where the money went. Where did the money go? Because we weren't allowed to introduce the evidence.
Thank you, counsel. So the court is going to take this under advisement. I'll get you all a ruling out before this afternoon.
Thank you, Judge.
Sounds good. Thank you, Your Honor.
You may be.
Belated birthday.
Thank you, Your Honor.
Thank you.
Maybe we be excused, Judge?
Yes.